3 words have just detonated Prince Harry's entire legal strategy: "You were untruthful." That is the accusation now hanging over Dr. Evan Harris, the star researcher at the center of Harry's £40 million lawsuit against the Daily Mail. And make no mistake, when a barrister accuses a witness of lying under oath in a British courtroom, the consequences can be absolutely devastating. Dr. Harris sat in the witness box for 3 consecutive days, swearing that he had never seen a crucial document relating to something known as Operation Bluebird. He claimed he had never been involved. He insisted the document was completely new to him. Then, like a grenade rolling across the courtroom floor, evidence emerged proving otherwise. Not only had Dr. Harris seen the document, he had rewritten it. He made substantive changes to the very memo he had claimed was entirely unfamiliar. Anthony White KC, counsel for the Daily Mail, did not mince words when confronting this contradiction. His accusation cut like a knife. "I suggest you've been caught out, Dr. Harris, and the evidence you gave yesterday was untrue. Let that sink in. This is not tabloid speculation or anonymous gossip. This is a King's Counsel directly accusing a key witness of perjury in open court. The implications are staggering. Dr. Harris is not some random researcher plucked off the street. He is a former Liberal Democrat member of Parliament and a former director of Hacked Off, the campaign group that has crusaded against tabloid journalism for years. His credentials were meant to lend authority and credibility to Prince Harry's case, to cloak the allegations against the Daily Mail in establishment respectability. Instead, his testimony may have handed the defense exactly what it needed to rip the entire lawsuit apart. Sources familiar with the proceedings described the courtroom atmosphere as electric when evidence of Harris's involvement with the Bluebird document was revealed. One legal observer put it bluntly: "This is the kind of moment that can turn an entire trial on its head." And they are absolutely right. When a star researcher appears to contradict sworn testimony, every piece of evidence they touched immediately falls under suspicion. The irony here is almost too perfect to ignore. Prince Harry has spent years condemning the media for alleged dishonesty, for twisting facts and manufacturing narratives. He has cast himself as a crusader for truth, the prince who would not be silenced, the man brave enough to take on the tabloid machine. And now, in the very courtroom where he hoped to expose media dishonesty, his own team stands accused of the same thing. You simply cannot make this up. The audacity of claiming ignorance of a document you personally edited is breathtaking. Either Dr. Harris has one of the worst memories in the history of British legal proceedings, or something far more troubling is at play. But the perjury allegation against Dr. Harris may only be the opening act in what is shaping up to be a catastrophic courtroom disaster for the Duke of Sussex. And the deeper the court digs into Operation Bluebird, the worse it appears to get. The stakes in this legal battle cannot be overstated. To understand why this drama matters so much, we need to step back and examine what Prince Harry has truly wagered on this fight. This is not a minor celebrity lawsuit over bruised feelings or reputational harm. It is a massive, multi-year legal crusade against Associated Newspapers, the publishing giant behind the Daily Mail. Harry and his fellow claimants have reportedly poured nearly £40 million into pursuing it. £40 million. That is the kind of money that could fund charitable causes for decades, transform entire communities, and do genuine good in the world. Instead, it has been swallowed by legal fees, court costs, and an army of researchers, experts, and witnesses, many of whom are now being systematically dismantled under cross-examination. At its core, the lawsuit alleges unlawful information gathering. Prince Harry and his co-claimants, including actress Sadie Frost and former politician Sir Simon Hughes, claim the Daily Mail and its sister publications engaged in a long-running pattern of illegal activity to obtain stories about them. We are talking about allegations of phone hacking, the use of private investigators, potential bribery of officials, the full, sordid toolkit of tabloid journalism at its worst. If proven, these claims would amount to a devastating indictment of one of Britain's most powerful media organizations. The problem is this: proving such allegations requires credible evidence and credible witnesses. And right now, both are in dangerously short supply. Dr. Evan Harris was supposed to be one of the central pillars of that credibility. His background as a former member of Parliament gave him political gravitas. His work with Hacked Off signaled a long-standing commitment to media accountability. and his research into Operation Bluebird, a clandestine investigation into alleged criminality at the Daily Mail, was meant to provide the smoking gun that would vindicate Prince Harry's crusade. Instead, his testimony has become a masterclass in how not to behave on a witness stand. Insiders say the atmosphere in the courtroom shifted dramatically once contradictions in Harris's evidence began to surface. One source described the defense team as barely containing their satisfaction when the damning documents were produced. They knew they had him, the source said. Everyone in that room knew. What makes this episode even more extraordinary is that the judge presiding over the case issued a stark warning before the trial even began. Addressing Prince Harry and the other claimants directly, the judge made it clear they had already sunk nearly £40 million into the lawsuit, and if they lost, they could be liable for an enormous additional sum. Legal experts have described this kind of pre-trial warning as virtually unprecedented. Judges typically avoid any remarks that might suggest skepticism or prejudgment. For this judge to issue such a caution suggests serious concerns about the strength of the claimant's case from the outset. Harry had every opportunity to settle. He could have cut his losses, walked away with his dignity intact, and preserved his finances. He chose to press ahead regardless. And that decision tells us something important about his mindset. This lawsuit was never just about damages or legal principle. It is personal. It is about vindication, about vengeance, about a deep need to prove that he was right and the British media was wrong. Harry has staked his post-royal identity on a narrative of victimhood. Admitting defeat now would mean conceding that the story he has told himself and the world may not be entirely accurate. But the judge's warning and Dr. Harris's credibility problems were only the beginning. What later emerged about the Operation Bluebird documents revealed a deception so brazen it almost defies belief. Let's break down exactly what happened in that courtroom. Operation Bluebird was the code name for a covert investigation into alleged criminal wrongdoing at the Daily Mail. The documents generated by this inquiry were meant to form a cornerstone of the claimant's case, evidence of systematic illegality that would prove Harry and his co-claimants had been victims of unlawful information gathering. Dr. Harris, given his background in media reform activism, was positioned as the expert who could authenticate and interpret this material. His role was to connect the dots, to explain how the evidence demonstrated years of unlawful behavior. When Harris took the witness stand, he was asked directly about his involvement with Operation Bluebird. His answer was unequivocal. "I was not involved in this work," he stated under oath. "Operation Bluebird is new to me." Clear. Definitive. Leaving no room for ambiguity. He claimed complete ignorance of the investigation and its findings. He portrayed himself as an objective expert encountering the material for the first time. The court accepted this testimony. The claimant's legal team likely breathed a sigh of relief. Then, the very next day, everything unraveled. Anthony White KC, representing the Daily Mail, produced evidence showing that Dr. Harris had, in fact, received the Operation Bluebird memo. But that alone was not the most damaging revelation. The real damage lay in what Harris did next. According to evidence presented in court, he did not merely read the document. He did not simply review it. He returned it with substantive changes, sections rewritten in his own words. Let me repeat that so there is absolutely no confusion. A man who swore under oath that Operation Bluebird was completely new to him had received the key memo and personally edited it. The barrister's accusation was precise and devastating. "I suggest you've been caught out, Dr. Harris, and the evidence you gave yesterday was untrue." The courtroom reaction was described as electric. Sources present reported a palpable shift as the implications sank in. One observer said you could see the color drain from the faces on the claimant's side of the room. Another remarked that the defense team looked as though they had just been handed Christmas, Easter, and every birthday combined. And it's easy to see why. When a key witness is caught in such a direct contradiction of sworn testimony, it doesn't just undermine that single point, it poisons everything. Every conclusion they reached, every document they touched, every argument built on their work suddenly becomes suspect. The implications for Prince Harry's case are potentially catastrophic. Dr. Harris was not a peripheral figure who could be quietly sidelined. He was central to the claimant's strategy. His research underpinned core arguments. His expertise was cited repeatedly. If Dr. Harris's testimony on Operation Bluebird cannot be trusted, then what else in his evidence is unreliable? That is the question the defense will hammer relentlessly, and it is a question the claimants have no convincing answer for. So how did Dr. Harris attempt to explain away this glaring contradiction? And does his explanation withstand even minimal scrutiny? The short answer is no. In fact, his defense only deepened the hole he had already dug. When confronted with proof of his involvement in Operation Bluebird, Dr. Harris did not deny receiving the document or making changes to it. He couldn't, the paper trail was undeniable. Instead, he offered what can only be described as one of the weakest explanations in recent courtroom memory. His claim was that this was not a falsehood, but an error, because the memo had not been shown to him to refresh his memory before he testified. Let's pause and unpack the absurdity of that argument. According to Dr. Harris, he simply forgot that he had received, reviewed, and substantially rewritten a key document in a £40 million lawsuit. Not a trivial email. Not routine correspondence. But the central memo of Operation Bluebird, the very investigation forming a crucial pillar of the entire case. The logical flaw in this defense is glaring. You cannot claim ignorance of a document you physically edited. You cannot describe something as new to you when you have rewritten portions of it. Making substantive changes requires engagement with the material, comprehension of its contents, and deliberate judgment about what to alter and why. This is not the kind of thing that slips one's mind, especially when testifying under oath in a case where that document is directly relevant. There is no comfortable middle ground here. Either Dr. Harris's memory is so catastrophically unreliable that he should never be trusted as an expert witness in any legal proceeding, or his original testimony was deliberately misleading. Compounding the problem is the timeline. This contradiction emerged on Dr. Harris's third consecutive day on the witness stand. 3 full days. Multiple opportunities to clarify or correct his evidence. And yet, not once did he disclose his involvement with Operation Bluebird until documentary proof forced his hand. Legal observers say this detail is particularly damning. One barrister not involved in the case explained that witnesses sometimes make innocent mistakes, but the pattern here suggests something more troubling. Failing to correct an error across multiple days of testimony, the source said, makes the "I forgot" defense almost impossible to sustain. And they're right. The explanation collapsed in real time and only made matters worse. What makes this even more alarming is that Dr. Harris is not the only witness whose credibility has crumbled under scrutiny. Earlier in the proceedings, another witness supporting the claimants withdrew their statement entirely, alleging that their original testimony, and even their signature, had been falsified. Think about that for a moment. One witness claims they were untruthful because they forgot. Another claims their evidence was fabricated without their knowledge. Either Prince Harry's legal team has assembled the most incompetent collection of witnesses in modern British legal history, or something is fundamentally wrong with how this case was constructed. The pattern is unmistakable, and the defense is exploiting it mercilessly. One legal observer drew an uncomfortable comparison. This mirrors other Sussex credibility issues, the same pattern of statements being made, only to be later contradicted by evidence. And here's the hard truth. When your witnesses are discredited one by one, when the foundation of your case begins to crack under scrutiny, you are not merely losing a lawsuit. You are losing the moral authority upon which your entire narrative rests. But the credibility crisis is only one threat to Harry's legal crusade. Because the defense has also raised a potentially fatal issue, one that could end the case entirely, regardless of the evidence. The statute of limitations. It may sound like dry legal jargon, but these 3 words could deliver the death blow to Prince Harry's case against the Daily Mail. Here's the situation in plain terms. Under British law, claimants have a limited window to bring certain legal claims. For the allegations in this case, the critical cutoff date was October 2016. If a claimant knew, or reasonably should have known, about their potential claim before that date, the lawsuit is legally barred. Time barred. Invalid. Dead on arrival. Associated Newspapers has raised exactly this argument against at least 2 of Harry's co-claimants. According to the defense, both Sadie Frost and Sir Simon Hughes could reasonably have known about their claims before the October 2016 deadline. If that argument succeeds, the implications are staggering. It would mean those claimants never had a legal right to bring this case at all. The trial should never have happened. Every pound spent, every witness called, every dramatic courtroom moment would amount to nothing, because the legal foundation was missing from the start. And once again, Dr. Harris sits at the center of the problem. Part of his role was to argue that crucial evidence had not been shown to the claimants before the cutoff date, supporting the claim that they could not reasonably have known about their potential claims in time. But here is where the perjury accusation becomes devastating. If Dr. Harris has been untruthful about Operation Bluebird, why should the court trust anything else he says? His testimony on the statute of limitations is now infected by the same credibility issues undermining all of his evidence. One legal expert put it bluntly, once a witness is caught in a serious contradiction, the judge is entitled to disbelieve all of their testimony. One rotten apple can spoil the barrel. And in this case, the rotten apple is not a minor detail, it is the denial of involvement in documents the witness personally rewrote. Sources close to the defense say they are confident the statute of limitations argument could be dispositive, capable of ending the case outright before any other issues are even considered. One insider described it as a kill shot the claimants have no meaningful answer to. The irony is hard to miss. Harry and his team had years to ensure this case was airtight, to verify timelines, confirm procedural compliance, and eliminate statute of limitations risks. Instead, they appear to have built their strategy on foundations now collapsing from every direction at once. Witness credibility failures. Procedural vulnerabilities. Contradictory testimony. One observer summed it up succinctly, a perfect storm of legal exposure. And yet, the problems don't end there. Because the pattern of witness collapse extends far beyond Dr. Harris, and each new revelation leaves Harry's position more precarious than the last. Let's be absolutely clear, the allegations surrounding Dr. Harris are not an isolated incident. They are the most dramatic example of a broader, deeply troubling trend. One by one, witnesses supporting the claimants are being discredited. Their statements challenged. Their credibility dismantled under sustained cross-examination. This is not bad luck. It is not coincidence. It is a systematic dismantling of the evidentiary foundation upon which Prince Harry's entire legal crusade depends. Consider again the witness who retracted their statement entirely, claiming their evidence was falsified and their signature forged. Either fraudulent evidence was submitted to a British court, or the witness is now lying to escape the consequences of their earlier testimony. Neither possibility inspires confidence. One legal commentator called it amateur hour in what should have been a professional operation. The defense has clearly identified witness credibility as the pressure point, and they are applying it relentlessly. Every inconsistency is exposed. Every contradiction amplified. Every gap in memory framed as evidence of a fundamentally flawed case. And insiders say the strategy is working exactly as intended, not merely to cast doubt on individual claims, but to undermine the integrity of the entire case from top to bottom. When your lead researcher is caught in apparent perjury and your supporting witnesses are retracting or contradicting their own statements, the defense's strategy becomes devastatingly effective. There is also a striking, and deeply uncomfortable, irony at the heart of this case. The original Operation Bluebird memo, the document now central to the controversy, was written by Graham Johnson, a former tabloid journalist who was himself convicted of phone hacking. Let that sink in. The claimants are relying on evidence produced by someone found guilty of precisely the type of illegal news gathering they accuse the Daily Mail of carrying out. You could not construct a more vivid illustration of the ethical contradictions at play if you tried. One source close to the proceedings summed it up bluntly: they're trying to prove media dishonesty using material written by a convicted media criminal, supported by witnesses whose credibility is collapsing in real time. The irony is almost unbearable. Royal watchers have drawn increasingly uncomfortable parallels between what is unfolding in this courtroom and the broader credibility issues that have followed the Sussexes throughout their post-royal life. The pattern is familiar: confident claims made publicly, followed by contradictions when evidence emerges, and then explanations that raise more questions than they answer. From statements in the Oprah interview that were later challenged, to assertions in the Netflix documentary that drew widespread skepticism, and now to this courtroom debacle, the through line is unmistakable. Say one thing. Get contradicted by evidence. Offer explanations that only deepen the doubts. But perhaps the most telling sign that this case was in trouble came before the trial even began. The presiding judge took a step so unusual that it sent shockwaves through the legal community. Judges in the British system are trained from the outset to maintain strict neutrality. They do not comment on the merits of cases before hearing all the evidence. They do not signal skepticism. And they certainly do not warn litigants away from proceeding. Which is exactly why the judge's actions in this case were so extraordinary. Before proceedings began, the judge addressed Prince Harry and the other claimants directly. The message was stark: you have already sunk nearly £40 million into this lawsuit, and if you lose, you could be liable for a massive additional sum. Legal professionals across Britain reacted with astonishment. One senior barrister described the warning as absolutely unprecedented in decades of practice. Another called it the clearest possible signal that the judge had serious concerns about the strength of the claim. The meaning was unmistakable. Without breaching judicial propriety, the judge was effectively telling the claimants to think very carefully about whether continuing was worth the risk. For a judge to issue such a warning suggests profound doubts about whether the case could actually be proven. Harry had every opportunity to take that warning seriously. He could have pursued a settlement. He could have negotiated a face-saving compromise that limited his financial exposure while preserving a measure of moral victory. He could have walked away with his fortune largely intact and moved on. Instead, he chose to press forward. He chose to gamble £40 million on a case that even the presiding judge appeared skeptical about. Observers who have studied Harry's legal approach say this decision reveals something fundamental about his mindset. One royal expert put it simply: Harry cannot retreat from battles with the media because his entire post-royal identity is built on the idea that he is the victim and they are the villains. Settling would mean acknowledging that this narrative might be flawed. The financial stakes are enormous. Nearly £40 million already spent, with the risk of far more if the claimants are ordered to pay the defense's costs. For Harry, who left the royal family in part claiming he had been cut off financially, the prospect of a crushing legal defeat could be genuinely ruinous. His Spotify deal has ended. His Netflix projects have underperformed. His memoir sales, while initially strong, have tapered off. The income streams meant to sustain his independent life are weakening just as legal expenses continue to rise. One financial analyst who tracks celebrity wealth was blunt: if Harry loses this case and is hit with substantial costs, we could be looking at a serious financial crisis. The Montecito lifestyle, security, staff, none of that is cheap. Add a massive legal judgment and the numbers stop working. But Harry's fixation on suing the media goes far beyond this single case. This lawsuit is part of a broader pattern that has come to define his post-royal existence. Multiple legal actions against British media outlets. Lawsuits over security arrangements. Repeated threats of further litigation. The prince, once known for his warmth and easy charm, has transformed into a litigious crusader, seemingly more at home in courtrooms than in charitable work or reconciliation with his family. Insiders describe this transformation as both sad and inevitable, the product of years of grievance hardening into something that increasingly resembles obsession. Consider the Netflix documentary that was meant to tell Harry and Meghan's definitive story. One of its most revealing moments came when it emerged that Harry had been filming himself during the royal exit, recording conversations, documenting events, building an archive even while negotiations with his family were supposedly ongoing. Supporters praised it as prudent documentation. Critics saw it as calculated betrayal. With hindsight, it reveals a mindset already oriented toward future conflict, already preparing for legal and public relations battles that had yet to be fought. This was not a man seeking reconciliation. This was a man assembling evidence. Royal experts warned that this addiction to litigation is costing Harry far more than money. It is costing him relationships. It is costing him credibility. It is costing him any realistic path back to his family. King Charles is battling cancer. Prince William has made clear, through actions if not words, that trust has been shattered. And still, Harry presses forward with lawsuit after lawsuit, seemingly more committed to proving the media wrong than to healing family wounds or building a stable post-royal future. One source close to the royal family put it starkly: Every lawsuit Harry files pushes him further away from any possibility of coming home. He's choosing courtrooms over family, and the family has noticed. Even the Invictus Games, Harry's genuinely admirable initiative supporting wounded veterans, has reportedly become another source of strain. Some involved would welcome greater royal participation, perhaps even Prince William's involvement, but Harry's ongoing legal wars against British institutions make that impossible. How can William appear alongside Harry at Invictus events while Harry is simultaneously suing media organizations William maintains professional relationships with? The collateral damage from this litigation extends far beyond finances. One psychologist who studies celebrity behavior offered a troubling assessment. Harry shows signs of what is known as litigation addiction, where the act of suing becomes more important than the outcome. The courtroom becomes the place where he feels power, control, and validation. But courts are designed to determine legal rights, not to provide emotional healing. And that, ultimately, may be the most tragic element of all. No lawsuit, no matter how successful, can fill the void Harry appears to be trying to fill. No legal victory can give Prince Harry back the life he left behind when he stepped away from royal duties. And the courtroom is not the only place where Sussex's credibility is taking serious hits. The pattern of promises made and promises broken extends far beyond legal proceedings. What is unfolding in court, the perjury accusations, the collapsing witnesses, the credibility failures, mirrors a much broader pattern that has come to define the Sussex brand in recent years. Consider what has happened since they left royal life. Spotify signed the couple to a reported $25 million deal to produce podcast content. The result was a single season that failed to meet expectations before the partnership was abruptly terminated. A senior Spotify executive later described working with them as dealing with grifters, a comment so blunt it went viral instantly. Netflix reportedly invested around $100 million, only to produce content that generated controversy but failed to establish the Sussexes as the serious documentarians they aspired to be. Initial viewing numbers were respectable, but interest quickly faded. Promised follow-up projects never materialized. Their charitable ventures tell a similar story. The Parents Network, launched with great fanfare, was quietly handed over to another organization during what was described as an incubation period. Translated into plain English, they started something, then passed it on to others to actually run. That is not the hallmark of committed philanthropy. It is the pattern of celebrity activism, enthusiastic announcements followed by disengagement once the unglamorous work begins. Sources connected to other Sussex-affiliated charities are reportedly watching this development with concern, wondering if they might be next. Even Invictus, the one initiative that has retained genuine credibility and delivered real benefits to veterans, is not immune to anxiety about long-term commitment. Insiders worry about becoming another project that fades when attention shifts elsewhere. One person involved expressed frustration that echoed what many now say privately: the courtroom mess just reinforces what people in the charitable sector have known for years. They want the accolades, not the sustained effort. The thread connecting courtroom failures and professional disappointments is unmistakable. Grand announcements followed by underwhelming execution. Confident claims that unravel under scrutiny. Early enthusiasm that evaporates when accountability arrives. Harry accuses the media of dishonesty while his own researcher stands accused of lying under oath. He claims to value family while remaining estranged from his father during a serious illness. He presents himself as a champion of mental health while engaging in behavior that professionals describe as self-destructive litigation obsession. The gap between the Sussex brand and Sussex reality widens with every passing month. So what does this legal disaster mean for Harry's future? And is there any path forward that does not end in catastrophe? Let's take stock of where things stand. His star researcher has been accused of giving untrue evidence about involvement with critical documents. Multiple witnesses have been discredited or withdrawn their testimony altogether. The defense has raised serious questions about whether the statute of limitations should have barred the case entirely. The judge warned before trial even began that Harry was risking enormous financial exposure. And through it all, Harry has refused to settle. Refused to step back. Refused to consider that his crusade against the British media might be built on shakier foundations than he believed. The lawsuit he would not abandon may prove to be the most expensive mistake of his post-royal life. We are talking about potential legal costs running into the tens of millions. Reputational damage that no memoir or streaming deal can undo. The spectacle of a prince who accused the media of dishonesty watching his own team face perjury allegations in open court. The irony is impossible to ignore. Harry spent years positioning himself as the truth teller, the brave voice exposing media corruption. Now he faces the possibility that this crusade relied on evidence that cannot withstand even basic scrutiny. If the statute of limitations argument succeeds, the entire case could be thrown out. Years of preparation and millions of pounds would evaporate because the legal basis was never there. If credibility issues continue to taint key witnesses, the case could collapse under its own weight. Every path forward leads through increasingly hostile terrain. There is no clean exit left. Royal sources say the family is watching these proceedings with a mixture of sadness and quiet vindication. Sadness because Harry was once beloved, seen as relatable, modern, and full of promise. Vindication because the institution he accused of dishonesty now watches him struggle with the very credibility issues he blamed on others. One palace insider put it with characteristic restraint: there is no pleasure in watching him fail. But there is recognition that the story he told about being the victim of institutional deceit was never as simple as he claimed. And that may be the ultimate irony of this entire saga. Harry sued the media for dishonesty. He built his post-royal identity around being the victim of lies and manipulation. He cast himself as the champion of truth battling tabloid darkness. And now, in the courtroom where he hoped to prove it all, his own case is unraveling under accusations of the very behavior he condemned. Sometimes reality delivers lessons no amount of money, lawyers, or publicity can prevent. So what do you think? Can Harry still win this case? Or has his war against the British press finally struck an iceberg it cannot survive? Share your thoughts below. Like, subscribe, and stay tuned. The next chapter is coming, and it may be even more astonishing than this one.